Everybody, it's Dave Stouts. I'm a partner and co-leader of Husch Blackwell's Data Privacy and Cybersecurity Practice Group. Joining me here today is Bob Bowman and Malia Rogers. For those of you who have joined us for our prior webinars, you're familiar with Bob and Malia. I'd like to start today by thanking you for joining us for our webinar. Obviously, things are a lot different than when we did these webinars a year ago. We know you were taking time away from your day, and we really do appreciate you guys joining us, and we're going to make it as worthwhile as possible. I think just in general, there's a ton to talk about today. And we've got a lot of slides, a lot of content here, and I think afterwards you'll hopefully see it the same way. So we'll sort of dive in, and I just think it's fun for everybody to kind of see what we look like as we talk, maybe just a little bit of context here. If you've attended one of our prior webinars, and actually, I've been remiss. I should say this to begin as a housekeeping item. There's the question answer function here. If you've attended our prior webinars, we do our best to try to get to your questions. Feel free to ask as many as you want during the program. If we cannot answer your questions during the program, we will get you an answer in the next few days, hopefully. Just shoot you an email. I think, if you've asked questions at one of our webinars in the past, that you tend to get emails from me at 2 o'clock in the morning on a Saturday or something like that, responding to things. So don't be shy. Ask questions. We'll do the best we can to get you answers. Okay. Another thing, if you've attended our webinars in the past, we like to start with a roadmap of where we're going. It lets you guys know what we're going to talk about. Maybe you can then hold off on some of those questions if you know we're going to talk about it a little bit. 3 topics to talk about here today. And we're going to start with an overview of the timeline and the implementation. I mean, this is really sort of taking a step back and saying where we're at with all these things and when they're going to go into effect as well. We'll talk about that. The lion's share of our conversation today is going to be on topic number 2. We're going to dig into the final regs and a ton on the statement of reasons and comments. That's really where the action's at in this round. Malia will talk about that in a second, but that's really where the action's at. And obviously the takeaways, we'll try to leave you with something to walk away from today. Okay, so digging in, the first topic is the overview and timeline for implementation. With that, I'm going to turn it over to Bob to say hello and talk about the next slide.
Good morning, afternoon, everyone. Thanks for attending. So just kind of to get everybody on the same page, we'll just start out with a little history of the regulations and then kind of play in some actual dates regarding the statute itself. So if you may recall, the CCPA was finalized by the California legislature in September of 2019. You'll see October 11th, 2019, the first draft of the proposed regulations were issued. And then January 1st, the statute went into place. February 10th, we got the first set of modified proposed regulations after a substantial comment in the review period. And March 11th, then a month later, we got the second set of modified proposed regulations. Again, just Monday, the proposed regulations were published, and then we're looking at 1 month after the final regulations were published. July 1st is the enforcement deadline, and I think Dave will get into this a little bit later, but put a question mark down for when these regulations would become effective. Mind you, the enforcement deadline starts in 30 days. Now I'll turn it over to to Malia to kind of talk about the final regulations package.
Well, great. Hello, everybody. So as Bob mentioned, this past Monday, Attorney General Becerra submitted the final proposed regulations, which we've all been eagerly waiting for. He submitted them to the California Office of Administrative Law, OAL is how it's referred to, and they are tasked with reviewing the package for procedural compliance, and then once approved, they file the final regs with the Secretary of State, and the regs become enforceable. Again, Dave is really going to go into the steps and timeline there. But what was included in the the regs was obviously the text of the final regulations. Most notably, they remain unchanged from the second set of modified regulations that we saw back in March. But if you drove compliance for the January 1 effective date of the CCPA, then there are substantial changes that have been made since the initial regs back in October through the February 1st modifications and then the March modifications. So we'll try to cover, some of those high-level changes and what the regs require. But as Dave mentioned earlier, we're really going to dive into what is new in the final regulations package, which includes the final statement of reasons. We saw the initial statement of reasons when the initial draft regulations were released back in October of last year. But between October to the first modifications in February to the latest ones in March, there was no explanation, no statement of reasons for what revisions were made, why they were made. So the final statement of reasons that came out explain these changes, whether it's just grammatical or stylistic, whether it's in response to comments. At times they provide further examples or context, and then as you'll see, many of times they're unsatisfactory. So we'll dive into this. Appended to the final statement of reasons is a summary of written and oral comments that the Attorney General's office received following the release of each of the draft regulations. So October, February, March, there were comment periods. So collectively here, there's over 500 pages of new material. After each of those draft regulations, collectively, the AG's office received 376 comment letters among those 3 comment periods. So that's really what we spent our time reviewing so that we can provide some further explanation, context, or at least identify questions that were raised that might still be unanswered. There's also an updated informative digest. It's a handful of pages that summarizes the amendments that Bob mentioned were made to the statute itself back in September. So those initial regulations that came out in October, in many cases, were in conflict with the statute because they did not account for those amendments. So again, that's really reflected in the first and second set of modifications to the regulations, and those reflect some substantial changes. And lastly, and another notable aspect of the final regulations package is that the Attorney General requested an expedited review. So I will let Dave detail the potential timeline and what an expedited review may impact in terms of effective dates for the regulations.
Yeah, thanks, Malia. So yeah, let me start with this, right? Because Bob said it, and I want to just kind of make sure that everybody's on the same page here. July 1st, the AG's office can enforce the statute. The CCPA is a statute. That happens on July 1st, right? So what we're going to talk about here is when can they enforce the regulations, right? But don't walk away from this thinking that it has anything to do with enforcement of the statute. That is coming. It's coming July 1st, period, right? So the situation now the AG's offices found themselves in is they didn't submit the regulations by the deadline to have them go into effect by July 1st, that enforcement deadline, right? They just didn't hit the deadline, right? And so the way this normally works is, I'm going to tell you what the normal process is, and I'm going to tell you what the AG's office has asked for. The normal process is once they file the final regulations, the final statement of reasons, the record, so to speak, with the Office of Administrative Law, the OAL has 30 working days to review it, right? If they say it's okay, they file it with the Secretary of State. And then, under normal procedures, the regulations, any regulations, unless there's uniqueness to them, become effective on a quarterly basis. So here, if the Attorney General's office was playing this by the book and had got them submitted in time, they would have been effective July 1st, assuming the Office of Administrative Law signed off on it, right? But as you know, they didn't, right? They didn't get it submitted timely, and it hasn't been, the OAL has not submitted or filed these with the Secretary of State by May 31st, right? So the presumptive new deadline is October 1st for when these regulations would go into effect, right? Adding further to that, obviously we're living in a COVID-19 world right now. An executive order was issued on March 30th that said, hey, that 30-day time frame for reviewing the regulations, you get an extra 60 calendar days, right? So that's what we're living in right now. If nothing else happens, we're looking at October 1st as a time frame. But wait, there's more, right? Along with the filing of the final regulations, the Attorney General's office also filed a request for expedited review and for an effective date upon the time at which the final regulations are submitted to the Secretary of State, right? So essentially what they're asking for, and you can kind of see the last phrase of this sentence here, they want the OAL to complete its review within 30 business days, and then they want it to become effective upon filing with the Secretary of State. That's the second line there, right? Now, having said this, this is just a request from the Attorney General's office. This is not, doesn't need to be accepted by the Office of Administrative Law. There's been no indication so far what the Office of Administrative Law will intend on doing this. We looked this morning. The OAL has this listed as part of its regular rulemaking in a list of 60 or so other regulations it's considering. There's a separate portion of the website for emergency regulations. It's not there. Doesn't mean it can't be pushed off to there. The point being is we don't know, and nobody knows. And if somebody tells you they know, they're wrong, right? Because we just don't know right now. And so what we're really looking for is if you do these 30 business days from the time that it's filed, you're talking about sometime in mid-July-ish would be like the earliest time period. But the default is October 1st right now, right? So I think for our purposes, and I think this is kind of important to get on the table early, right? If you're looking at this as your in-house counsel and you say, what do I do, right? Well, if you've done nothing to date, you don't have CCPA compliance done at all, really July 1st is that line in the sand for you, right? Get something done. If you've done something, you've driven compliance with maybe the initial regulations, and so you're looking at updating it, then I think the answer there is get started. There's a lot to be done. You're going to need to update it, whether it's October 1st, whether it's, July, anybody's guess. There's no reason you can't get started, right? So I think that's sort of a reasonable, practical approach here. Okay, so let's shift gears here. Let's start talking about the final regulations and the final statement of reasons. This really is where the action's at here. We're going to start with some general observations, then we're going to go through a few of the different articles and give you some backfill here, right? So bullet point 1 is it confirms what we suspected, right? And this is important too when you're driving compliance, right? The final statement of reasons states, and the comments state, that when the initial regulations came out, they did not incorporate the amendments to the CCPA that happened in September, right? So you may recall the legislature had a number of amendments on September 13th. The legislature closed. It was a Friday. The amendments passed. There was things like the business-to-business exemption was added. The employee information exemption was added, right? So there's a lot of changes to the CCPA that happened at the 11th hour. The initial regulations, we suspected that they didn't include those amendments, and it was confirmed, right? So this is really a frame of reference for people when they're looking at their compliance is, the initial regs didn't even take into account the amendments to put that into, the thought process as you're driving compliance and what you need to do to update to the final regs. The second bullet point there is going to sound like an incredibly shameless plug for legal services, but when you go through the 500 pages of comments, and sadly we did go through the 500 pages of comments, you will find that this reference to, we just don't know, go consult an attorney who's aware of the pertinent facts and relevant compliance concerns. This is, I haven't done a search for it, Bob, but I imagine this has got to be in there like 500 times or something like that, right? I mean, it is basically the AG's office consistently says, we don't know, just go talk to a lawyer, right? And you're going to see that in some of the quotes that we show you as well. Okay, Some other general observations, just from the comments and looking through the comments, the business-to-business information exemption, a number of requests to clarify that, and they were, basically turned down. They didn't want to clarify it. HIPAA, there's this reference in here that I think is sort of interesting with respect to companies who are HIPAA-covered entities. And, essentially they say you determine the delta of its compliance obligations between the two. Not very helpful, but I know, for the entities, the HIPAA entities that are on listening in, I know that's going to be significant to you. I know we've got a ton of GLBA financial institutions on the webinar. A number of comments in Appendix A, so that'd be the first round of comments to the initial regulations. There was, a lot of attempts to clarify the exemption there. It was all resisted. The only thing I would say is that they did clarify that, what we already suspected, right, which is the GLBA exemption is not an entity-level exemption. It is specific to the personal information itself. I know on our end, we've been saying that since the very beginning, so it was reassuring to see that was, in fact, the outcome here. There was some discussion in the comments about, like, hey, how does this relate to our GLBA notice? Should we provide the disclosures the same notice, different notices? And the AG's office just basically said, do whatever you think makes sense. So I'll have Bob talk about GDPR real quick.
Yeah, one thing I think that we've kind of had focused on along the way was that, compliance with GDPR is a total separate animal from compliance with the CCPA. And the final statement of reasons, the AG's office confirmed that in answer to a comment. Basically, their quote was, because of key differences between the GDPR and CCPA, they're different requirements. And so, you can't rely upon being GDPR compliant and then assume that you're also CCPA compliant. But the other issue that we've talked about before a little bit, and we looked at some of the proposed comments in one of our last webinars, and or proposed amendments, I think it actually was, where there was a proposal to set some standards as to what would be considered reasonable security measures for which companies could rely on in order to satisfy that requirement. That comment was additionally made, and in the final statement of reasons, again, the Attorney General's office kind of punted on that. And it kind of said, just because there's a whole bunch of different situations, we aren't going to provide any guidance as to what reasonable security measures could be, and it's going to be on kind of a case-by-case, fact-specific determination. One of the things that, I've thought is they could have provided, let's start back that they have purported or put forth a definition of personal information, so they know or should know what that personal information is. And then also based on consulting with industry experts, they could have easily probably provided a reference to known security standards as kind of at least the floor for reasonable security standards. I think that would be really helpful to people instead of it's basically trying to hit a moving target. But it is some confirmation that they are at least kind of unclear as to where it's going to go and how it's going to be enforced.
Yeah, and Bob, it's also sort of notable, right, because those who are long-timers in this space will know that in 2016, the California Attorney General's office, under a different Attorney General, issued a report, the 2016 Data Breach Report, and they said, the CIS-20 constitutes the minimum level of standard for security, right? And so this is kind of striking, right? Because we have the same office who said 4 years ago it was the CIS-20 was the minimum level, and here they're telling you, we'll know it when we see it. I mean, it's just sort of indicative of what's going on here. So, don't lose for those who are familiar with that and we're thinking of that. I'm sure I've got 12 questions right now on the CIS-20. I mean, it's striking. It's very much striking. So let's dive in then some of the definitions and some of the clarity here. So, the top one, I think we baked this in a long time ago, but it was reassuring to see, maybe reassuring because we got it right, maybe not reassuring to businesses about what the $25 million threshold is in relation to. They did come out and actually definitively state that the $25 million threshold for being a business is all in. It's global. It's not just in California or California residents. With respect to credit unions, I wrote an article on this back in the day on whether or not credit unions are covered, and you can go look on our blog if you're interested in that. But they refused to say, right? They refused to say whether credit unions are covered. They were presented with a question and said they want to take a position on it. And then the doing business in California, we've had that question come up from a number of different clients. Hey, what does it mean to be doing business in California? And basically they said, well, it's the plain language and look at other California law. Frankly, that's not, the plain language is a little bit aggressive there. But that's essentially where we had counseled clients as well, that to look at other portions of California law to get a definition of that. Definition of sale. I don't even know what to do with this one, frankly. There were a ton of comments asking them to clarify the definition of sale. As I think is ubiquitous in the privacy space, everybody has looked at the definition of sale and they've said, okay, guys, I understand when money transfers, that's a sale, but the phrase other valuable consideration, Dave, what does that mean, right? What does other valuable consideration mean? Is it defined? I said, guys, it's not defined, right? So they were asked to clarify, and this is right there was their response. They say the terms valuable and consideration are reasonably clear and should be understood by the plain meaning of those words. That's the AG's office comment. It is not mine. Do not get angry with me, right? That's kind of astounding, to be frank. And given the number of questions we received from people on these topics, it's really kind of hard. It's a difficult to look at that and think that there's an opportunity for them to really provide some clarity, and they didn't, right? On cookies, and we're going to talk a lot about cookies in a little bit in the service provider context where it really comes up. But they asked, this is the question so many of us have wrestled over, right? Are third-party advertising cookies sales under the CCPA? It was presented to them, and they did not answer it, right? What they said there is it's a fact-specific determination, talk to a lawyer, right? And they had said things like, whether or not monetary or other valuable considerations involved, whether there's an intentional direction to disclose the information. So I think that raises questions such as cookie consent banners and the like. But point being, the AG's office was squarely presented with the opportunity to say whether or not third-party advertising cookies are sales. They did not do so. I have my point of view on it, but for your purposes, there we go. Some helpful insight here from the final statement, reasons, and comments with respect to the definitions of categories of sources and third parties. This comes up in your privacy policies, right, when you have to describe who you collect this information from and who you share it with. And so basically what they told you is you got to explain it. Let me say it this way, right? They've got now the definition of these two terms, and they identify a bunch of different types of entities, right, or categories. What they're telling you is this is not exhaustive. You're not stuck to this list. What we want you to do is we want you to explain this in a way that the consumer will understand it, but you also don't have to name names, right? You don't have to sit there saying we collect from Facebook or we collect from Google or all those types of things, or you don't have to name the names of the entities that you transfer the information to, right? So some helpful guidance there. This one's, this is another one that sort of was interesting to see how it developed. If you've tracked our webinars in the past, you'll know that in the second round of regulations, they added this section saying guidance on interpreting the CCPA definitions, right? And they basically stated there, as I've got in the stated section, this concept of, hey, an IP address standing alone is not personal information, right? They came out and basically said that. So they published that in February, and then, a couple weeks later, they deleted it, right? And we talked about this in our prior webinar. We're like, God, this really signals confusion on the issue when you add something to clarify, and then you immediately delete it. Their response to this, their explanation was at the bottom there. They deleted it to prioritize the implementation of the regs, and further analysis is required on this issue. Okay, so it basically tells you like they're still trying to figure it out. You know, that said, and Malia found this comment last night. You know, there was a question they asked whether an IP address is personal information. And again, I mean, it's going to sound like we keep on putting this phrase in there, but we don't, right? I swear it's there. A fact-specific contextual determination, you talk to an attorney, right? So again, these are unsatisfying answers, but they are in fact the answers the AG's office is putting forth. Okay, so we've kind of motored through that one. Obviously, we got a lot of content. I'm going to go ahead and turn it back over to Malia to talk about the notice to consumers.
So this is section 304 of the regs, is where it starts, and section 304 specifically was added in, I believe, the February modifications, and basically it provides a roadmap as to the type of notices that are required and whether a business is going to be required to provide these notices. So there's 3 notices. If you collect PI, then you need to provide a notice at collection. If you sell PI, then you need to provide a notice of right to opt out. And if you offer financial incentives or a price or service difference, then you need to provide a notice of financial incentive. So we're going to cover the notice at collection and the notice of right to opt out, as those are applicable to most clients and people on this phone. If the financial incentive is applicable, you know, feel free to contact us offline. So first is the notice at point of collection. There is some clarification here. So it only applies to businesses that are collecting personal information directly from consumers. If, however, you don't collect PI directly from consumers, or if your consumers have the option to provide personal information on other individuals, maybe it's filling out a form or application, a business is not obligated to then somehow contact those other individuals to provide this notice. So there's a few caveats there. If you do fall into one of those categories of not directly collecting the information from consumers, then you're prohibited from selling that information. If you intend to sell that personal information, then you actually do need to contact those consumers and obtain their explicit consent. So for most businesses, if you're collecting personal information directly from consumers, the notice at point of collection requires that you provide this notice at or before the point of collection of the categories of personal information that you're going to collect and the purposes for which that personal information is going to be used. In the regulations and reaffirmed through the final statement of reasons and responses to comments, this notice doesn't have to contain all that information up front in that notice, but the notice can drive to a section of your privacy policy that contains that information, the categories of PI to be collected and the purposes for which it's going to be used. But what's really was driven home in the comments, evidently maybe there was some confusion, but your privacy policy alone, without any notice that an individual would encounter, is not sufficient. Having your privacy policy online does not satisfy your notice at point of collection. The notice has to be both timely and physically encountered at or before the point of collection, but otherwise the regs and AG's responses to comments is that they're giving businesses great flexibility and discretion into how to communicate this information to their consumers. So here's some examples. If you have a mobile application, it states to have a link or this notice in your settings menu or your download page. If you are communicating with your consumers over the phone or in person, you can provide a notice orally. If you have a physical location, prominent signage or hard copy papers of notices is fine. It even addressed in the comments that QR codes are acceptable on the sign that then directs consumers to your online privacy policy, the section of that policy that contains the requisite information. If you have forms or hard copy forms, adding an addendum. And then most importantly, if you have an online presence, the regs require you to have a conspicuous link on the introductory page to your website, as well as all pages where personal information is collected. So there's been discussion around, we've seen cookie banners up because IP address, cookies, et cetera, are listed as personal information under the CCPA. So as soon as someone lands on your website, you need to be providing them this notice. But how do you go about doing that? So in response to comments regarding this, the first quote there is that the AG said, this provision of the regs does not require a cookie banner, but it's up to the business to determine the formats that best achieve the results in the particular environments. So again, somewhat vague. And there's also a question of, well, can you put that notice as a link close to your privacy policy link? Consumers are kind of used to looking for your privacy policy in the footer of your website, but is that something the consumer would encounter at or before the point of collection? And the AG kind of dodged responding to it directly, saying, we'll see the examples that we've provided in the regs, which are, the ones we just went over here. So still not a clear answer, no definitive yes or no. So I think we'll still continue to see these cookie banners and links and variations of how businesses determine to implement this notice at point of collection. One last thing to consider is if you are having an abbreviated notice or a link or signage that ultimately drives to your CCPA section of your privacy policy, note that the notice at point of collection is forward-looking. You need to be providing information on categories of information that are going to be collected, the purposes that you're going to be using this information for. The privacy policy requirements under the regs and CCPA are backward-looking. You need to be disclosing the PI you've collected over the prior 12 months since your last update date to your privacy policy. So just a consideration in terms of how you navigate providing this notice. The other items that, if you drove compliance in January that are now different since the March modifications, is the requirement that notices in general, including your notice at point of collection, need to be reasonably accessible to disabled consumers. The regulations decipher between online and offline or other notices, and if you are online, any generally recognized industry standards are acceptable, and they specifically incorporate by reference into the final regulations the Web Content Accessibility Guidelines from the Worldwide Consortium. So there's been a lot of talk about complying with those requirements, both for your notices, your privacy policy, and I know we've kind of discussed that in more detail in prior webinars. Otherwise, your notices need to at least provide information on how a consumer could access the notice or policy in a different format. And another thing to highlight is that these notices are important because businesses are then going to be limited in how they use that information based on what they disclosed in that original notice. So businesses can't use personal information for materially different purposes than originally disclosed. So ensuring that the purposes you're putting in these notices is broad enough to cover the current or general uses that you're going to use the information for. And the intent behind that is to give consumers meaningful control over how their PI is used, such that if you are ultimately going to use it for a different purpose, then you actually need to go and get consent from those consumers. You can't just put passive notice updates on your website. Employee notices. So employee-related information is generally exempt from the CCPA through until January 1 of next year, but you are still required to provide the notice at point of collection to California employees. And the main takeaway here is, again, that there were substantial changes from the initial regs in October to the latest modifications from March, so the final regulations at this point. So if you drove compliance for a January 1 date and provided that notice to your employees, it would make sense to go back, look at that notice, and refresh it. Some of the substantial changes are really almost walking back the way in which you have to disclose this information. You no longer need to link each category of PI collected to the purpose that you're going to use that information. And you no longer need to have a do not sell link in there or a link to your online privacy policy. So there's just some changes that you might want to take a look at. And in drafting those employee notices, we just wanted to highlight this response to one of the comments, which basically is the Attorney General acknowledging that your list is not exhaustive when it comes to the personal information categories, and that really the idea is to give meaningful information to your consumers. So if you're collecting a certain category of personal information that doesn't necessarily fit neatly within the example list that's provided in the statute, then there's flexibility there. And I will hand it over to Bob now, who's going to go over the second type of notice, which is the notice of right to opt out.
Thanks, Malia. So as Malia indicated, the second notice is the notice of right to opt out of the sale of personal information. So I've posted in the slide, this is the amendments that were in the March version, but this is the final version as well. There were some comments directed towards these revisions, and you'll see that the originally, the Attorney General's office and the regulations had some qualifications that involved future, like may in the future sell, and that the notice says that you will refrain from selling in the future. The reason for this revision is that I think in answer to a lot of the comments being that this is too limiting, what if we want to change the way we do business? And so the statement of reasons indicated that the final purpose is the notice just must convey the current business practices. You know, this also though gives kind of a forewarning that just be aware that if your business practices change, you'll need to include corresponding updates to your privacy policy and your notices. Here's kind of a review of the general requirement. A business that sells consumers' personal information shall include the following in its notice of right to opt out. So you have a description of their right to opt out, and then the required method for which such request can be made. So if you do not sell personal information and you state so in your privacy policy, you do not need to provide this opt-out. One of the clarifications in the March version which carried through was that, like the notice at collection, for mobile applications you can use a link at the bottom of the download page. Maybe a difference, I'm not sure, is that with the notice to right to opt out, you also have to include a link within the application in the settings menu, so you have to have both. So a new kind of concept was added in the March version, again, which carried through into the final version. I just wanted to note that. So essentially, they've kind of created a limited window in the time between a business receiving the request to opt out and then by the time that that request is acted upon. If there are any sales of information from the business to a third party, you have an affirmative obligation to go back to that third party as part of your response to the request and notify them that they should not be selling that person's personal information. And finally, I've seen some of the comments here, and you'll note that the opt-out button pulls a magic trick. Now you see it, now you don't. The reception the opt-out button by the privacy community was so emphatically negative that that they pulled it real quickly. And most of the comments were like, what you presented was unclear and confusing. And in a way to placate that and justify the removal of this, they've basically said that they're going to further develop and evaluate a uniform opt-out logo or button for use by all businesses. So they've kind of just, I think, threw something out hastily. That was not well received, so now they're going to try again. I'll turn it over to Dave now to kind of go through the differences in the requirements for your privacy policies.
Yeah, thanks, Bob. So what I've got here is 3 slides that basically, and I won't go through all of them. You can download a copy of the deck here to kind of see the differences, right? But let me just kind of highlight a few of them. What we're doing is basically telling you the initial regs when they came out in October, which a lot of people drove compliance with, versus the final regs. What do I need to do to my privacy policy, right? And so these are essentially the changes. On this first page, really the one to kind of focus on is the last 2 lines there. They backed away this requirement to link up the categories of personal information to the sources and the business purposes, right? So, for our clients, when we were driving after this back in December, we had these boxes and we were linking all these up, right? That's gone with respect to linking it up with respect to sources and business purposes. That still remains with respect to linking up the personal information to the transfers outside the organization, to service providers and third parties. So you're still going to have a box in your privacy policy disclosures. It's just the box is going to be different, okay? But it's better for businesses here. It was a walk back. It got it closer to the statute, and that was the reason why they stated they made this change. On the next slide, just to kind of point out, they made a sleight of hand change with the whether you're selling information for minors under 16. Now they added this phrase knowingly. We had a number of clients flag this along the way, which is, isn't this really a knowing standard like in COPPA? So they did make that change. And then on the authorized agent front, they changed the prism by which they want those disclosures to be made. The initial prism and the initial regs was to say, how can you designate someone as an authorized agent? And commenters said, well, why is it our job to tell consumers how they can designate an authorized agent? That's not what we should be doing. And the AG's office agreed, and they said, really what they want now you to say, what they're requiring you to say, is, how an authorized agent can make a request. And then the last slide here on this one, there's these, Malia talked already about the disabilities language where they changed that, and then they're pointing to a specific standard, something really to think about here on this topic. So let me then kind of talk about, some of this context here with the comments, right? A ton of comments came in on the privacy policy. You saw this happen from 2 different point of views. Some people said you're doing way too much, you're way too prescriptive. Other people said you're not doing enough. You should require specific things, right? The AG's office just basically said, we've done what we've done. It is what it is, right? We thought about it. This is what we're going to do. What they've resisted is they resisted the idea of providing any sort of model notices. They said maybe there's something they'll think about in the future, model notices or model language. I know we've talked about in prior times, we thought about, hey, it'd be a good idea if they came out with template language. That'd be really helpful. They said, maybe down the line. And they also really, they specifically, and there's the comment in the left side there, they specifically said that they're not going to harmonize the requirements under CalAPA or GDPR or any other privacy law for privacy policy purposes, right? This is the criticism of how many pages are these things going to be at the end of the day? Should we have, and there's a lot of content out of, Europe where they say things like, how you should draft your privacy policy and how you should use your table of contents and, menus and all those types of things, right? The AG's office stayed away from those. And I think also it's really disappointing in the sense that they have CalAPA and they have the Shine a Light Law in California. And, CalAPA is under the jurisdiction of the Attorney General's office. And so there was a real opportunity for them to synthesize those two and make life a lot easier, and they just said they're not going to do it. All right, so with Article 3, I will hand it back over to Malia to talk about the changes here.
Great. So I'm going to cover the methods for receiving and responding to requests to know and delete. And I'll have Bob go into the opt-out requests. So no change here, obviously, since March. Requests to know, requests to delete generally require you to have 2 or more designated methods for receiving consumer requests. Requests to know specifically require that you provide consumers a toll-free telephone number by which they can submit requests to know. And otherwise, you can choose your second method to be any of these other methods: a designated email address, hard copy forms that can be submitted in person through the mail, providing a web form on your website. What was different between the initial regulations to what are now the final regulations is that it removed the requirement for the web form. And as we've mentioned earlier, this was really just to bring the regulations in alignment with the amended statute. And in the amended statute, the CCPA really only requires businesses that are exclusively online and have a direct relationship with consumers. In that narrow instance, businesses only need to provide one method by which to receive requests to know, which is a designated email address. If you aren't operating exclusively online and don't have a direct relationship with a consumer, those 2 requirements, then you need to provide 2 methods, one of them being the toll-free telephone number. And we've had clients ask, does it have to be a live person? Can it be a recording? The regs are not prescriptive. So we've had clients doing both if you have an existing customer service center, but also monitoring a voice message is so far okay. The web form, though no longer required under the regulations or statute, we have seen clients who are using it have benefited to the extent they are receiving consumer requests. It allows the business to collect more information up front in a web form and then streamline your response process. So while not required, definitely seems to be a helpful avenue as one of the methods to receive requests. When it comes to requests to delete, there is no designated or mandatory method, regardless of how you're interacting as a business with your consumers. Just need to have 2 or more designated methods. Similar examples: a toll-free number, a link or form available on your website, an email address, and forms submitted through the mail or in person. In both instances, though, the regulations require that a business consider how you're primarily interacting with your consumers. So if you do interact primarily in person or at brick-and-mortar locations, providing some sort of method for consumers to exercise their rights in person. It doesn't mean necessarily an oral request or a hard copy request. The regs now provide examples of having a tablet or computer portal in your store or brick-and-mortar location, having a telephone available to consumers to use in order to call the toll-free telephone number. So there is great flexibility here, but generally, if you have any sort of online presence but aren't exclusively online, then you really need to be providing at least a toll-free telephone number for requests to know. And if you want to streamline these methods, providing the same 2 designated methods for both requests to know and requests to delete makes sense, but is not required that they be exactly the same. One of the clarifications that was made in the modifications is that the responding to requests to know and requests to delete require that a business provide a confirmation within 10 days, and it was clarified that this is business days. Similarly, you need to provide a substantive response to consumers within 45 calendar days, with an option to notify the consumer that you need an additional 45 calendar days, so a total of 90 calendar days. What was reiterated both in the statement of reasons and in response to comments is that the verification needs to occur within the initial 45 calendar days. And if you aren't able to verify, then you deny the request. So using verification as a justification for extension is not going to be accepted. And when it comes to the 10-day confirmation response, some businesses or commenters, complain that it's hard to respond within that certain period of time. And the AG's office responded that this is not a tailored to an individual response. It can be generic because they changed the requirement that you need to be providing just a general summary of your verification procedure in the confirmation response. So the AG, as you can see in that quote, responded to a comment saying this 10-day response should be prepared in advance. It can be automated, so it shouldn't be too much of a burden. Additionally, they confirmed that if a consumer, for example, is providing or submitting their request via phone, that you can provide this 10-day notice orally, the same manner in which the request is received. One question that we've addressed with some of our clients who are putting processes in place for responding to these type of requests is, can we set a limit on how soon a consumer needs to actually respond with verification information? Because requests to know and requests to delete require that a business verify their identity to certain degrees, and I think Dave will go into that later. But there was a specific question saying, how must a business respond when a consumer fails to provide a verified response within 45 days? The Attorney General's office responded, as they have with some of these other issues, is that the regs are not going to go into this level of granularity. It's a fact-specific and business-specific question. Consult an attorney. So what we've really been advising is that, it's the business's obligation to comply, verify, and provide a substantive response within 45 calendar days. And it's reasonable then to require or request your consumer to provide responsive information within a reasonable amount of time so that you're able to go through your verification process and data mining process. So we've seen variation between providing some sort of response deadline and perhaps providing a reminder or a couple reminders within that time frame. Absent any response, going ahead and denying that request is acceptable per the regulations. If you're not able to verify in 45 days, you deny the request. And this is just, again, a high-level overview of what those substantive changes were for responding to requests to know and requests to delete between the initial regs and what are today's final regs. A lot of the modifications to what you need to provide in those substantive responses were in light of aligning to the amendments within the CCPA. Originally, the regs seemed to extend beyond what the CCPA's language had. And the difference between request to know and request to delete, which is pretty clear in the regs but was further teased out in comments and responses, is that requests to know are the only type of requests that businesses can limit consumers to submitting two of those type of requests per 12 months. And in responding to those requests to know, businesses only need to provide or disclose responsive information for the last 12 months preceding receiving that request. Requests to delete, however, there are no limit on the number of requests a consumer can submit of that type. Obviously, if you're deleting their information, it's unlikely they need to be submitting numerous of those requests. And when it comes to requests to delete, the consumer has the right to request a business delete any personal information that the business has collected. There's no 12-month look-back period. And also in the comments was hashed out the idea that it is limited to, it needs to be individualized. You can't provide a generic response. And then there's exceptions there in terms of archived data or data that is inaccessible and only kept for legal or compliance purposes. I will hand it over to to Bob to go through the opt-out requests and responses.
All right, thanks. So this is going to kind of just be a high level of what your requirements here are for the request to opt out. So you must provide two methods to receive requests. One of the changes in the regs was that they changed it from a web form to an interactive form to have more general application. And you can select which two you want from a toll-free number, designated email address, a form submitted in person, a form submitted through the mail, or user-enabled global privacy controls. And I will leave it up to you to determine what those are. So one of the interesting comments was that someone asserted that two methods is not prescribed in the statute. And the Office of Attorney General's office, in their infinite wisdom, just said we were given the authority to determine acceptable methods, and this is what it's going to be. Slide. So one of the concepts that was really addressed in the last two issues of the regs was this recognition of global privacy controls or settings. So it is listed as a specific method above, but it seems like that it's probably required in addition to the two methods to receive requests, because not all popular browsers will offer this. I've looked, I did a little searching, I couldn't really find any browsers or plugins that exist globally for CCPA compliance. I did find one for some specific aspects. And that kind of aligns with the Office of Attorney General's office that admits there's not really standards right now for businesses to rely upon in the existing technology, and that they'll probably have to revisit and issue additional regulations on this concept. So, just kind of be aware that that's probably something coming down the line that the browser companies are going to offer as some sort of global privacy settings that will apply to each website that you use. So your development of your website may have to adjust accordingly. And then this is just kind of that a rehashing of the obligation before, that if you sell a consumer's personal information to any third parties after they've submitted their request, but before you've responded, you shall direct those third parties not to sell that consumer's information. So just a small window of responsibility, but one that could potentially get you in trouble if you kind of forget about it. So pass it on to Dave here, who's going to talk about service providers. But before I do, I'll just mention that we have other webinars and material slides on like time periods and everything to comply. And so if you're looking for that information, just let us know and we can direct you to those resources.
Yeah, thanks, Bob. So, we're short on time, so I'll just kind of hammer through the rest of these slides. And this one here is basically just comparing, this is service providers, right, and how service providers can use information under the CCPA. So this one compares, what was allowed under the initial regs versus the final regs. Obviously, a ton of more avenues for service providers to use personal information. This is important, so I want to make sure I get to it. What they said in the final statement of reasons is they said you're required to have these service provider contracts, right? So if I'm a business and I transfer information to a service provider, I'm required to have a contract to make them a service provider. And the contract has to say certain things. What the AG's office said in the final statement of reasons was the AG's office has the right to enforce those contracts and to view violations of those contracts as violations of the CCPA. So they are saying they have the right to enforce, third-party contracts. Responding to requests, this just sort of demonstrates how this changed from the first regs to the final regs for service providers here in particular. So, if that's of interest to you, like take a deeper dive. What I really wanted to get into is these last three slides. It essentially gets into cookies and the like. This was a response to a comment in Appendix A, and I'll let you read this for yourself. It's pretty dense, and I'm not going to read it to you. But the point being is, I think this is a comment that really is going to get a ton of traction, a ton of writing over the next year or so. And what this essentially is, and it goes back to that quote I gave you on whether third-party advertising cookies are sales. But what they're saying here is, hey, you can use a service provider to furnish advertising services. Those ads can be shown to the same consumer on behalf of the same business on any website, right? So, people are going to start thinking about third-party advertising cookies, the Googles and the Facebooks of the world. I think this is something that really is going to get a lot of a lot of discussion over the next year. There's no answer here. The AG's office isn't coming out and saying something definitive, but that phrase there about being able to share it across websites is really going to be something that's going to be focused on. This is kind of fascinating as well. A comment asked them to say whether Google Analytics and Adobe Analytics, whether they be considered service providers under the CCPA. And again, the Attorney General's office said it's a fact-specific determination, and you should go talk to an attorney. This is really, tons of companies are using analytics, if not almost all companies using analytics, either through Google or Adobe or another platform. And, Google's taken its own position on whether GA is, they have restricted data processing. It's kind of remarkable, though, for the Attorney General's office to say this is fact specific and not take a stance on this. And session cookies as well. So the question here is, hey, we want you to exempt session cookies, right? They're not persistent identifiers. Here, you did get some traction here from the Attorney General's office, where they said if a session cookie cannot be used to recognize the consumer, family, or device over time and across services, it would not fall within this definition. So, really, I think this started to answer this question of whether the phrase the word persistent modified cookie, and I think that this answers it and does say, they're viewing the word persistent to modify cookie in the definition of unique persistent identifier. To give you some frame of reference, right? There's all these questions about cookies from the directed Attorney General's office, and as you've seen, there's been really no answers, right? And there's also been things on IP addresses and things of like. This is really in substantial juxtaposition from the EU, right? And this is just two examples of data protection authorities in, well, I guess one's in the EU now, the UK is no longer, but there are pages and pages and pages of what you need to do about cookies and tracking technologies that the EU has published on this. And these are just two examples, right? And the AG's office isn't there yet. Clearly, the AG's office isn't there yet. Maybe we'll get content in the future, but right now it's just not there. Verification of requests, just kind of motor through this, given we're short on time. Nothing's changed in the password-protected accounts or on the non-account holders here. This is all the same stuff as it was before. Very modest changes to these, and let you read over this in your free time. The takeaways from the comments, I went through these yesterday, right? There's over 30 pages of comments and responses on the verification procedure. Those people saying, do this, do that, it's too much, it's too little. The AG's office just basically said, we're not going to change it. But what is clear from it, though, is that they want you to have a thought-out and well-documented procedure in place for verification. This is not get the request in and figure out verification. They want you to be thinking about this in advance. So takeaways, then. This is the last section of our thing. It's one slide, so hang with us if you can. Number one, right, the timeline for effective data regulation is unclear. We talked about that before. But again, if you've driven compliance to initial regulations, I think the answer now is get started, right? Get started. This is not hair on fire, call me on the weekend, type stuff, right? But this is let's get started, let's think it through, let's come up with a plan. However, if you didn't drive compliance already, July 1 really is the deadline, right? That's when enforcement starts. And so I think, you're in a unique situation now where you can drive enforcement on the final regulations, but it's time to drive enforcement. Update your privacy policies is number 3. Number 4, Malia talked about this before, right? Privacy policy does not equal notice of point of collection. This is something that really I think is not getting picked up on, and it should. You have to think about these two as different. And then validating the methods and processes for responding to requests. We talked about that. I always call this the shameless plug section of our presentation. We've got a blog. If you're not subscribed, I hope that you will. We push out a lot of good content on that blog, I think, and it's a way for us to keep on talking to you guys in between our webinars. And then we've done a lot of webinars too. I'd just highlight, if you're interested in CCPA 2.0, Malia and I did an on-demand webinar a couple weeks ago now. The links are there if you need them, and that's also available on YouTube. All right, with that, we've stayed over our welcome here by a few minutes. I appreciate you guys hanging with us. If we didn't get a chance to answer your questions, we will go ahead and do so in the next few days. Again, really appreciate you guys tuning in, and we'll chat with you all soon. Thanks.